Well, I want to thank you all for joining us. I'm Mark Schumacher. I'm the CEO of the Home Furnishings Association, and you have joined us for one of our ever popular webinars. And today we're tackling what I would just tell you is a complicated subject, but one that you really need to pay attention to because everybody has a part, I should say, in compliance and also some concerns about this area. We're talking about data privacy laws, and they are changing in a big way, have been, are doing so again, and we're going to delve into this so that you're armed and ready to go. I do want to make mention, though, of course, we have an amazing library of webinars. This one will be added to it. Just go to myhfa.org/webinar to find our complete library there. We also thank Synchrony. They are our thought leaders when it comes to our education programs here at HFA. And by the way, also at the bottom of the screen, you'll see there's a Q&A tab. If you have a question, please put it in there. We'll do our best to get to it before we are finished today. But we have a great panel. We always do. The team does a great job of bringing people in here. A couple of familiar faces. You're going to recognize Richard Harris. He's with Orbit Interactive, a full-service digital marketing strategy company and agency. Richard, we're always glad to have you here. Eric Grinley also joins us, CEO and founder of Esquire Advertising, also full service. And when it comes to advertising technology, et cetera, and branding and everything, they're on top of it as well. Eric, always appreciate having you on board. And joining us, new face, is Laura Mahoney. Laura is the general counsel for Strong DM. That's a leading provider of identity-based access control. And she's going to be somebody we're going to lean on heavily here for a lot of expertise. So Laura, thank you for joining us. We appreciate this very, very much. You know that this is a tough one, I got to tell you, because it isn't just one-dimensional. We're not sitting here talking about the fact of, hey, this new privacy law was passed and we need to now adapt to it. We're talking here about, in the last 2 years in particular, I know there's at least 5 states that have different privacy laws, data privacy laws. There's an international law related to the European Union. So there's a lot going on here. So I guess the real question I'd like to start first, and Richard, I'll start with you on this one first, but can you capsulize, I guess, just initially, what is changing and what, kind of where we are in this whole thing, just as a little bit of an overview?
I think it's not really as much changing as making sure that we're aware. So when California rolled its law out, it was because they were tired of waiting for the federal government to roll one out. And the one for federal government has been kicked the can for probably the last 7 years. And they went ahead and rolled one out, and it follows a lot of the one for the European side of things, but there's some things that are a little different. As that rolled out, though, it also got other states to look at it and start doing that. And it's one of those, as they're rolling through this, we need to make sure that we understand what the expectation is, what the transparency level has to be, and then what are the compliance issues that we have to have, not only for when we advertise, but also for the client on their site, on their data, what they keep as far as even from credit card information and other things, and how they reuse data and information they have when they send back out messages, whether it be for text or email or regular old mail. So what are they doing with that data and that information? So all of those things have come under question, and you just need to make sure that you have a understanding of what the rules are. And I think I'm sure there are other folks here will sum up. You're never going to be perfect, but you got to kind of get as close as you can to a good system and show you're doing your best to be in that system.
So it's really risk management for each business, obviously. I mean, it's a key piece of that. Laura, do me a favor, and how would you categorize or characterize this from the standpoint of urgency for any business owner at this point? I mean, how much risk are they really seeing through these regulations that have been coming down the pipe?
Sure. I mean, I think, obviously all companies in all different industries are being challenged by the lack of uniformity in the privacy rules, the speed at which these technology and privacy laws are changing. And I think it's really a matter of really assessing at almost a very frequent cadence your risk and trying to adjust your business practices accordingly. No one is going to be able to be completely compliant with all these different rules. I mean, it would just be borderline impossible. I would suggest that companies look at it the same way they look at their advertising priorities and spend, right? It's not going to be equal in all different jurisdictions that you're in. You're going to be updating it constantly. Look at it that way. You're going to need to figure out for you specifically as a business, what are your biggest risks, right? And having an active defense posture is really important. So it's not that you have to be 100% compliant, but being able to say, look, we have done a review of our privacy policy. We have reviewed our cookie notice and updated it. It's important to be able to have a stance that says, we're thinking about this. And, some people might say, oh, I'm not one of the big 5 companies in the world. I'm not Google, like there's no one coming after me for enforcement. And sure, being fined is one stake of this. But there's also other carrots here, right? There's sales too, and you might be able to actually land bigger logos and increase your sales if you're able to have a privacy policy that addresses some of your customers' concerns and be able to say, look at what we've done, and it might just put them more at ease. So I think there's a lot of different factors to consider here, not just, are we big enough to be fined, or, do we need to be 100% compliant?
Super helpful. We'll get into more of that, the profit standpoint, which is an important thing. I'm glad you brought that up. Eric, I think just before we dig into all these elements, what do you think the percentage is of retailers out there that are really aware of this?
I think people are thinking about it, but it's probably very low, in all honesty. Most people don't pay attention to these things until it's staring in the face, right? So
Right.
It's likely that most retailers are not thinking about this at all. But in reality, there's so much regulation out there in the world, and when it's not really addressed at the federal level, which privacy laws really haven't been, it creates almost like a compliance nightmare. And so your best bet, usually for most retailers, is going to be like, look at one state, that obviously the state that you're in, but then also look at one state, and usually people would use California as the standard, and say, I'm going to comply with what California says to do, and make sure that I'm just going about it in a way that's going to be meeting sort of the gold standard.
Okay, fair. So let's
say the one thing I'd say on that is kind of, because if you, and maybe it's not completely related, but I think it is in a way, in 2017 they rolled out ADA compliance. So making sure that sites had the ability there for anybody from any sort of disability to come in. And to this day, there are sites out there that don't have fully, ADA compliant sites, but most of those fines and things happen in like 2018, 2019, the big cases that we saw on TV and made the internet, made everybody come up with products, and then it kind of died down. But one of the things that happened then was you had lawyers that developed, that was all they went after. And then they've slowly been cranking through different companies based on, how long they could see it do it, and they're still coming after.
This is still a threat. It's still a threat. Yeah. There's no doubt about that. So Laura, what are on the surface of it, what are the threats to a business owner when it comes to these types of data privacy laws out there? What's the biggest threat? Is it a fine? Is it a lawsuit? What are they, what should they be concerned about most?
I think it would be, reputational damage, honestly, mostly. Like if it's unlikely, unless you are a huge company, that you're going to be fined, but it's not impossible. And, if there is a scenario where someone asks for you to delete their data and they find out you don't, and they're loud about it, just reputationally, I think that's going to harm you. And frankly, there's a lot of things that you can utilize. There's a lot of tools out there you can utilize, and just parts of tools that that a lot of businesses use probably already in their CRM systems and similar, where just knowing that you have them available to toggle on or off, or update that cookie notice to show that you're aware of what, disclosures you need to give to people when they're on your website, or what you want to be able to let them opt out of, right? Just enabling that functionality on the back end. I think that really, really does help with the risk mitigation. It's not, it doesn't have to be a, tens of thousands of dollars and a huge undertaking just to have at least the real building blocks of an active defense posture there.
So Eric, what's the thumbnail of what should a furniture business owner really, what should that checklist look like right now? Because what we don't have time for in this forum is to go through line by line these laws that are out there. Just know that they've got to get educated on them. So what are the things that they should be doing to make sure that they are protected?
Sure. So the first thing they need to do is understand what data are they looking at their business. So where are all the data points, and where do you hold that data? What do you use your data for? And then making sure that you're taking reasonable steps to protect it. I think the biggest risk for any retailer right now in the space is not that they're in violation of one particular privacy rule. It's if they, if they have a data breach. And I think you're gonna, I don't think it's public knowledge yet, so I'm not gonna reveal who the retailer is, but there was a retailer in the last 6 months that had a very extensive data breach at their, of their locations, their stores. And I think what you'll find is that they're gonna end up having probably some lawsuits that'll come out of that because of the fact that they probably weren't protecting the data as well as they should have been. And so therefore they're going to have liability. And then these privacy laws will come into play in those cases to say, hey, you know, you were supposed to be doing this, that, or the other thing that they weren't doing. So that's where the real risk becomes, is like, if you're not taking steps to protect what you're holding, you know, and then you have a data breach of some sort and consumers' data is released because you weren't taking care of it, then you have a much bigger risk. So understand where your data is, take steps to protect it. And then if you're using that data for anything, make sure at the very least that you have a pretty simple mechanism for all of your customers to be able to opt out of things, opt out of the usage of that data, that they can ask for to be deleted and removed, and that you have some sort of policy. I always used to say when I was a general counsel of an internet marketing company was, you know, you want to have basically your compliance binder. You want somebody to come in and they say, hey, tell me what you do. You want to be able to pull out this book and put it on the table and say, here's all of our policies. This is where our data is held. This is what we do with it. This is how we utilize it. These are the steps we take to protect it. You have all of that in writing, so you can say, hey, look, you know, on a reasonable person basis, when you're looking at this, we took all the necessary steps that are required of us.
Gotcha. And I guess we're saying, and Richard, if you want to pick up on this, please do. It's not about being perfect, right? It's just about showing that you are aware, that you're working to be compliant, that you're responsive. Is that fair?
And sometimes it's looking for those extra, like we had to buy a pseudonym converter. So it takes data from somebody's CRM, basically converts it to where we don't see the name and the information the way it would come over. So what we're getting is just the part we need. And then we're using that to do our targeting, do a base, but we don't have the person's information. And then when we kick it back to the client, it goes back through the pseudonym piece and tells them who the person is, so they can do matchbacks and such. But those types of things, so that we can work with data without being in violation for somebody to be private. It's just finding the tools and places out there to do it.
So, you know, we talked, you know, we've talked a little bit about this whole, you know, this whole concept of you know, not every retailer is like front line in this whole thing, right? So a lot of times there's a third party that's doing a lot of these different things. Laura, is that any protection for a business? Say, well, but that's handled by X agency, or that such and such does this. Is that defensible, or is that not something that you can just lay off on a third party?
I mean, it's not a silver bullet, but it certainly does help. Yeah, there are a lot of things you can do out there with third-party vendors that will definitely help your risk mitigation and getting the right, you know, Eric spoke to breaches, making sure that you know, have tools in place to help mitigate the likelihood of a breach as well. So I think the aggregate of all of that, definitely a great step forward. I mean, it's not.
Then let me go a little step further with you then. So if I'm because I'm always trying to think about this from the business owner standpoint. So if I'm engaging a third party, this is something I need to be bringing up, that I need to be really talking to them about this compliance part of it, and all of these different privacy laws that are out there. I mean, is this something I need to take an active role in to make sure that I'm holding their feet to the fire before I just entrust a third party with anything?
I mean, it's really gonna, yeah, you do, because you need to see what liability are they actually willing to take on for you or not, right? Just because it looks like they might be an attractive like vendor in their name doesn't mean that their T's and C's don't actually like totally disclaim any liability or indemnification that they would have for you. So I think it is really important to have someone, you know, whether it's your in-house counsel or external counsel, or someone who understands what's actually in that agreement with that vendor.
And Eric, I saw you nodding.
Yeah, I mean, I was going to say, you know, like one of the things too is that, you know, a lot of like people hold data in a lot of different places, right? So you might have a point of purchase system, you might have a CRM, some retailers are just holding a lot of data in like spreadsheets on their computers, and they have, so a third party, in my opinion, is probably going to tell you that like, look, like we can only be as compliant with these laws to the extent that you are, because most of it is all about reporting, right? So, you telling me that this person needs to be removed, or me telling you that this person needs to be removed. And if you don't do those things, then they're never going to be in compliance, but they're also not really sort of violating anything because you haven't told them yet. So the whole law, it requires that there's basically different positions, right? Someone that's storing data, holding data, someone that's acquiring data, someone that's processing data. Everybody has their different rules and different ways that the law applies to them. And so it's important that you understand where you're holding your data and what the third party is doing with it, but also like, making sure that you have a process in place to communicate with them when you need to update something. Because if you don't, then like you're basically in violation, and they'll never be in compliant because you never told them to remove a record.
I think just to follow on what Eric said, I think that your baseline position should be that these vendors are not going to take on all the liability of all their customers, right? It would not be a scalable business model for them. So the likelihood that they require, like Eric said, like X, Y, and Z, and maybe it's an update to them, or that you follow certain things, is very, very likely. And you need to know what those things are so that if there is protection in that agreement, you're able to avail yourselves of it, because they're just not going to take on the risk for every single customer that they have.
Yeah, I say, because we usually have a DPA, so it's a data processing agreement that's there that says this is what we do, this is how we use it there, but it also has the audits in there. So it tells you what we do and how we audit, and what our kind of audits, periodic timetables are, and what our expectation is from the client, as well as what the client's expectation from us should be. And it's just a clean way, to Eric's point of, making sure that both people are kind of held to a certain part. But if the client's not doing their end, but we did our end, again, then it turns over to that same problem of, well, you're in trouble, but this person took care of their part, you didn't take care of yours. So you can't push it off with the other person's taking care of it as well.
And Mark, one thing to mention too is that one of the biggest, like, I think maybe sigh of relief for most retailers should be, is that really there isn't much a private right of action in any of these things yet. And that's really what's holding up the federal level too, is that it's this debate over whether or not there should be a private right of action for, a citizen to be able to basically sue someone over, violation of these privacy laws. And so, being compliant and just knowing what you're doing on a daily basis and where you're holding this data and taking your best steps to protect your customers' data is gonna, it should breathe a sigh of relief to most retailers, but they just need first to understand where they're holding it, how they're holding it, and making sure they're just taking steps to protect it.
Yeah, let's talk a little bit about that, because I think you've stumbled onto something that's critical here. No matter how sophisticated a third party might be, if you are storing your data on 5 different systems, and you don't really have a specific way that it's done, and just kind of, well, we compile it there, put it on a list. I mean, let's talk about that, and I'll throw that out to anybody that wants to jump in first. But let's talk about the necessity for anybody listening to this to make sure that you're cleaning up your data storage, and you've got a data storage plan before we even worry about these other compliance pieces. Let's talk. Who wants to jump in on that one?
I can speak to it a little bit.
Go for it.
Look, for most of these retailers, they accept credit card payments. I'm sure they accept credit card information. Hopefully they're not storing credit card data in a manual form. But like, that would be my biggest risk, I think, for most of them, is like, payment information. Obviously they have to protect their consumers' data just in general. And if you're spreading it around amongst, 10 different systems, and your employees have free access to it, and you're not protecting it just in taking some basic steps, like you can't just be storing people's data on your personal computer without any protection on it. So if they're not using a third-party service to store their data, they actually should start using some sort of third-party service. So that way, at least they have someone that's working on the compliance side of it for them. But my fear is that for probably 60% of the retailers that are out there, the small business ones, the small guys that, they are still doing things manually in the stores, that are still doing paper receipts and writing things down, they're probably the ones that are most at risk, just because they don't have any way to, they don't have any formalized system. But again, it goes back to, there's not likely going to be a private right of action. So, it's hard to say what the end result of any would be.
Yeah, I think for me, the thing that the line, however, that Laura said that is the biggest concern, though, is reputational damage, right? Because they might have, maybe somebody can't take it to court over right now, but boy, in the court of public opinion, it could be tough. Richard, any thoughts on?
Yeah, well, I mean, I guess the way I look at it
is,
is the data side of things. I mean, we've seen it with different mainstay retailers and things out there that have had issues with the credit card data gets leaked and this, and you see it pop up on, hey, go protect yourself with this information. But I think the difference here is we're not talking just credit card data. We're talking about where you live. We're talking about, sometimes, stuff that people have done for designer stuff, pictures of people's houses and interiors and things. There's a lot of other data that we collect sometimes that we don't think about as a retailer. It's there, and depending on where and how it's been stored, it can be an issue, because it's also, how have you trained your employees to deal with it? Because if you're not training the employees on what they're supposed to do with it, I mean, I know one place where they write down credit card information by hand on paper. Well, I know that's not SOC compliant and hasn't been for years, but that is, it's a no-no, but that's the way the employees are still doing it. And, and they'll take that information over the phone. And I'm like, okay, who's controlling that piece of paper? Where did that go? How did you destroy it? There's a lot of pieces to those things. And I think that's the part that it also is a little scary, is there, because the definitions, as we kind of talked about, a lot of these rules are either very broad or not really super detailed. They leave themselves open for interpretation. A lot of things fall into it. And that would be my fear, is what's going to fall into it and what is going to be considered.
So a question came in, I think it's a really a good one here. So and they were asking this in relationship to California companies, managing these issues. This one mentioned about employee devices. A lot of retailers now are doing that thing where you might get a customer gives you their cell phone number, and you're texting back and forth and things of that sort. It's that personal touch everybody's looking for. Can we talk a little bit about, and we'll use California as the example, since Eric said, let's use that as the litmus here. And I'll throw this out to whoever wants to answer it. What are the concerns there, or are there any concerns there with that type of usage of customer information?
I mean, just to communicate to them?
Sure. Just, I mean, how does this all, fit in to any of these laws when when I'm using a device? I'm not just, sending to somebody's email address, but I'm actually communicating directly.
I mean, I think that's the problem with most of the laws, is that they are very broad, where you could say basically all the information, all the data is covered under it. And therefore, by putting it onto a separate device in order to communicate with them, that you are responsible for protection of it on that individual device. And then technically, if the person asks for it to be removed, you have to remove it from all those individual devices, right? So,
Wow.
Yeah, I mean, and I think that's the problem, right? That's why a federal law would actually be great in privacy, because what you don't want to have is that we could actually end up with 50 different privacy laws in 50 different states with 50 different things to comply with. So, if that happens, it becomes much more difficult. I think retailers, it's very interesting. I don't think that the furniture world yet has really been struck by this, but in a lot of other verticals, people have gotten into a lot of trouble for text message communication.
Mm-hmm.
And that is something where you actually can be sued, and there are states with a private right of action for violation of basically that's considered under, I think, the telecommunications law. But so there's a lot of things there and a lot of potential for hazards, and it goes beyond just even the privacy rules that you might be violating.
Laura, what are your thoughts on this whole aspect?
Yeah, I mean, it's hard, because I think a lot of the practices, in ad tech and otherwise that were once considered mainstream and broadly deployed are definitely starting to be scrutinized. And so, I think there has to be a posture of being careful not to collect more than is necessary. At the end of the day, could you lean on that it's for a business intent, right? It's the same as if you were emailing their business email address to talk about your product. There's like legal justifications. But you just don't know at the end of the day what that particular state or that particular judge might come down with. So it's very hard to navigate. I think there has to be like a risk assessment there.
Richard, let's continue on this a little bit further, because I guess the real question is that so what do you recommend to the folks that are using texting as an example? I mean, it is data, right? To text, you've got to have their phone number. Is it like Eric said? I mean, I think about when I get solicited out of the blue, via text, it's like most of them are basically saying, put stop if you don't want this anymore for an opt-out. Talk a little bit about that, because there's a lot of retailers. We even had a follow-up question here that was asked about the texting part of it.
Right. Well, and you're supposed to have consent. So you can't technically just text everybody blindly without some sort of consent. And what most people use is that consent rule. There was a case, it's probably about 4 years old at this point, where it was a dentist office sent a bunch of texts out because the dentist office rebought another dental practice, and somebody's text to say, "Hey, I'm the new dentist, come on into me." And he didn't technically have the right to send all these out, but then it was ruled that because were patients that had already taken action and done business with them, it was part of that consent that they had signed as being a patient that they could solicit and market to them because they're patients. And that opened up this whole kind of wide span that we see now with, different apps and things in the back end that do reputation and such to say, hey, if they've done business with you before, we can send them a text. But that still means that somewhere in that information, somewhere it says we have the ability, you have to be putting that out there in writing. And if it's not there, that does still open you up for that liability, because you don't have the right to text somebody without some sort of consent. And they have to known about that consent somewhere in the thing. So it could be in the purchase order, it could be in the side, that it has to be in there. And we find a lot of clients don't have it in there, but they constantly want us to send out lots of text. And it opens you up for that risk. And, as Eric said, this is so broad in identifiers. They're looking at name, address, IP address, geolocation data, any other data link that could identify somebody's ID. And then you get to somebody like Virginia, and it says, and if you can tell they're a Virginia resident, we're going to count that too. Yeah. So it's like all these little layers of things in there. I look at when they launched Colorado law, literally 10 days before the law went out, they changed it. It was so tight right before that you couldn't even do business in Colorado as far as advertising. And then they changed it right there at the very end, so you could actually run ads, because we're going to have to shut down everything in Colorado the way it was originally written. So I think there's a lot of challenges too, that as these states are rolling it out, they don't understand the technology and they don't understand what's currently out there. They just know they want to protect consumers, and they want to give consumers that protection and that transparency, but they don't fully grasp all the different technology that's out there and all the things that are collected. And sadly, neither do consumers, but that does affect sometimes what we can do from an advertising, what we can do from a text, and what we do from email.
Mm-hmm. Yeah, best practice. Yeah. I would just say, for anybody who's asking about text messaging, obviously, like the best practice on text messaging is that the first text that you send to them should be a text asking for them to give you permission. You're allowed to send them one text message to ask for permission to text them, and get that consent over the first text message. Don't just start marketing to people over text because they checked a box on your website or signed something on a receipt. Your best practice is to always ask permission over text.
Well, but what if you're, and I know this is going to come up as a question, what if you're in the store and you've been working with this person and you say, hey, do you mind if I text you more information? Is a verbal okay? Or are you still wanting that in that first text that you officially send to them?
I would want it in writing. I would put it in the first text.
The first text?
Yeah, okay. First text. That's your consent.
That's okay. It's a huge, I'm glad we got two lawyers on this call. Because I'm not qualified for that.
And then clearly having that wording in there, like you mentioned, Mark, opt out, hit stop, unsubscribe, knowing, because I've gotten some that I know personally, if I write back unsubscribe, they will stop, and some that say it. And so you should have it clearly in there, can opt in and how they can opt out. You shouldn't assume that someone has gotten so many of these that they know.
Okay. And another question I wanted to ask you, all three of you too, for a clarification. And this is one of the other questions kind of surrounds this. So as an example, the European Union rule, the GDPR, one of the things that is in there that I find interesting, and I think I've seen it in one of the other states as well, is that it does say there's a, I don't want to call it forgiving, but it's one of those things where it just basically says, let the person know what you're using it for, which we've talked about. But then it says that does not open up the floodgates for you to do everything else. You've got to keep it within that scope. So can we talk a little bit about that? And Laura, I'll start with you there, because I think a part of this is don't, I think that at least what I'm trying to say is, I think what I'm hearing is this does not open the floodgates. Just because you asked for this one thing doesn't mean you can then now just market this person to death if you wanted to. It still has to be within what you really gave to them as the premise for why you want to communicate. Am I correct, or am I taking that too far?
Yeah, no, you're correct. I think that I think that companies need to keep it narrow, right? They need to be careful to just collect what they need to collect for that narrow business purpose. And if they want to go outside of that, they need to get consent to go outside of that. And if you can show that you're doing that, that's going to be leaps and bounds above what other people are doing. I definitely think you need to keep it narrow. Don't go selling it to a third party if you're not disclosing that you're selling it to a third party. You're just opening yourself up to a lot more regulation and a lot more scrutiny. And so just, the whole premise behind protecting the consumers is that there's notice, right? There's disclosure and consent to doing it. So it's not, no one is saying you cannot do something provided you get their consent, right? You just need to be honest about it. Honesty is the best policy here.
My mom used to say that.
Yeah,
do you have
I
any-
don't know. I mean, that's because, like you mentioned, Mark, they're the people who are putting in place these laws and regulations are not thinking about it, thinking about what consequences, unintended consequences possibly that these laws will have on retailers, right? They're not doing that. They're thinking about the consumer, and they're thinking about how they don't want that consumer to have their data being used in ways that they didn't consent to. And so, unfortunately, there are a lot of unintended consequences, and it is making it very complicated for these retailers and manufacturers. But there's no easy fix to that. The only fix right now is to get that consent and give the ability for people to opt out.
Yeah, and we said, I think earlier we said it was really a private right of action side of things open. Well, California does allow it. It's not a big, it's like damage like $100, $750. It's not a big damage size per incident, but consumers can seek that statutory side in California. The rest of the states, for the most part, it all goes to the attorney general that has to enforce it and such. But again, that's why when we say if you go by California, there's a pretty stringent. It's a good safety measure, but that they do have that risk there, and there is a lovely firm there now that's their new job. So they're hunting down consumers who feel like they've been abused by different, whether it's retailers or businesses and such, and that's what they're going after.
So, great question that came in prior to our webinar today. That since we talked about texting, I think this is interesting. It just says this is just a kind of a good basic question: can we make digital cold calls, or can we make digital cold calls? Or is that risking if you're just putting something out there? I mean, I get what they're saying, right? It's just like, it's that wide range blast out there. Are there any things that are an issue with digital cold calls?
And I assume you're talking about the robo style calls on the digital side?
You take it wherever you want to take it.
Well, because robocalls, I mean, they're annoying, but they're not technically illegal. You can roll robocalls if you want. There's obviously there's lots of blocking side of it, but when somebody says digital calls to me, there is also the ability to generate, lookalike audiences and start going after those lookalike audiences with custom filings and such like that. And there's a lot of stuff now that's gone into audience-based targeting. Even Google has moved all of its business towards that goal, because it is supposed to be more giving, because it's just the audience seems like that, and you may have an interest, but if it's, we still can't reach out to them without their approval though, via text or emails and other things. But you could send them ads, you can put videos in front of them, you can do other things because they fall into that audience base, but you're not gonna be able to do that physical touch, as far as I see it, as far as truly talking to that individual.
Okay. Any other thoughts, Eric? Do you have any?
I would be careful with anything where you're, essentially like spamming the person, whether or not that's by calling them, texting them, or emailing them, or obviously like calling is really interesting because you have that telemarketing sales rule that comes in. You have to scrub it against the do not call list. And I don't know, I actually don't know the answer to this, and it'd be worth looking into whether or not, if someone gives you permission to call them for a marketing purpose, but they're also on a do not call list, like how that works. And
wow. No, good point. And I think when they say digital cold calls, I don't think you're talking about a physical call, but I get it. I think you guys both made a great point on that. Let's talk money for a minute. These regulations in these 5 states, all of this tightening of this digital data and privacy issues, is this driving up customer acquisition costs? Is this something that folks are paying? I see Richard, go ahead. If you want to start, to see you nodding.
Well, I'll say there's no way it's not. I mean, because one of the things that, the first way I would even go is, when we started getting rid of third-party data, and third-party data was going away because the federal law was being kicked around for a while, and it was saying, hey, we're not gonna be able to do this. It started driving up, okay, well, we can't tell where somebody is, what they're doing. And it was very clear to go towards that European model. We started needing to collect first-party data. We started getting that rights in there. We need to start building those audience profiles. And you saw that big motion and movement to that. That's why every major site says, will you accept my cookies? But the reality is, you got 30 to 40% of the people accept cookies. The rest of them don't do anything, or they say no, and don't do anything is the equivalency of no. So, you don't have as much information as we used to. And, I'll pick on Facebook. Facebook used to be fantastic. I mean, I cannot say nasty things about them 10 years ago. Today, I would say it's the most vanilla targeting you could possibly find, because it doesn't really have any teeth to it. And it's not that it's a bad product. It's just doesn't do what it used to. You used to be able to get instant sales for doing some ads for very little money. Now you're spending a lot of money to get the same level. And so that obviously is costing you more money. It's costing more to acquire the client and everything else from there. So yeah, it has changed, the ad business from that standpoint, as costs are going up. And even if it's not necessarily the price per thousand have gone up, or the cost per thousand may have gone up, you're going to have to spend more money to get the same reaction.
I think you'll probably see the elimination too, because what ends up happening is that when the laws come out and change and makes things more difficult, a lot of smaller businesses basically get wiped out from it. So, the larger companies, the people that have spent the time to build their systems to be compliant from the start, then can start actually charging more money for it. So over time, it probably will end up increasing prices, but I don't think we've seen that happen just yet.
Laura, are we going to add to that?
I was just going to say that's a good point, and it's an interesting juxtaposition to all of the antitrust regulations and guardrails there too. So I don't know.
Well, and I'll say that's what they did overseas, because they have the trust centers overseas, which is a shared collective first-party database. At the end of the day, it's if you collect them in first party, they're basically an accounting firm that says, oh, this person collected first party. They validate that 11 points of contact, or that fingerprint match. And once they validate it, then those folks can share information back and forth, as long as there's no transactional or money value in it. And that's their way of working across the walled gardens. But we're still seeing Google, we're still seeing Facebook take fines for some of that, because they're just stretching the line a little too far overseas. And that's where, if you're looking down that train of where it's going, I do see us falling to that place where we'll have a, trust centers and full system in place to where we can share data, but it's not here yet because there's not enough states with it in compliance.
Yeah.
Okay, I want to bring a little sunshine to this conversation for a second, because we've been talking, all this stuff is just like, I can see that every business
The glazed eyeballs.
It's like going great. Well, but glazed because of just yet something else to think about. All right, so what are the opportunities out there to leverage this and maybe make more money? I guess is the question. So how can a business take this and leverage it, whether it's reputational, whatever it might be? What are your suggestions, Eric? I'm going to start with you. What do you think is a way that a retailer can actually take this and turn it to their advantage?
It's hard to say, because I don't know that you can really take, the privacy privacy rules and turn that to your advantage and make more money off of it. I mean, I guess maybe you could try and run some advertising to talk about how you protect your customers' data. But quite honestly, I don't think consumers are really thinking about it all that much. I think more or less they need to look more at it from like a risk management standpoint and mitigating their potential risk on the back end. So yeah, I don't know. I don't know that there's really a way for them to make more money off of privacy laws changing and stuff. But if anything, maybe this will make them look at their data more. And the more you look at the data that you're holding, the better you'll understand your customer. And so therefore, the better you understand your customer, the more money that you can make. They need to, I mean, that's probably the best thing that'll come of it.
I like the way you got to that. You had me going out here for a minute, and then you run right back in.
I think you might, partnerships and being able to show that in the chain of the ad process and the sales process, you are not going to be the part where something breaks, and that breach might happen, might also help. Like you want to be able to partner with other companies, and you want to be able to say that you're doing what you can. So if you do go out and you are breached, and that's a reputational issue, then it is going to be harder. That's going to help you lose sales. So
see, I see it in a way that we're getting ourselves, or forcing ourselves into that omni-channel relationship. So when we talk about the marketing standpoint, we've always talked about all these different channels to market, but on the omni-channel side, a lot of it falls after the sale. And right now, there's not a big investment from advertisers on the after the sale side. They may see it as, I invest in my drivers, but as far as what do we market and what do we do? And now if you're collecting the information on that consumer, you're using that to remarket to them in a way to get them to the next sale, the next opportunity, the next product. I do think there's a way to but it's a backwards way, almost like how Eric kind of circled back, but it's a backwards way of, yes, we'll make more money at this, but it's by utilizing our information better and putting more efforts into finding that consumer who's been, hey, you've already liked me. We've already done business. I was able to attract you with whatever branding opportunity I ran earlier. Now, how do I pull you back in to buy one more item, to come back one more time and make you a raving fan? And I think that's where the biggest opportunity comes from, is for everybody to understand how to take their current data, clean it, rinse it, protect it, do what we have to do, but then also start utilizing that data and use it for the right purpose, which is to drive sales. And I don't think they're really using their current data to drive sales, because if I got $2,000 left on my card, the furniture guy should be telling me I got $2,000 left on my card. Come on in and buy something. They should be sharing that information with me, because, maybe my couch, the dog just ate the corner of it. I'd like a new couch. So, those are the opportunities I think that are missed. And I think that this kind of forces, the business to start thinking, going, yeah, we really should be, looking at our data. How can we do it? Because this should be a big chunk of their sales. I mean, your biggest sales should be from current customers.
You've given what you've done, and this is why you guys are here, is you've given a real carrot there, right? Because if I'm just going at this as strictly as a compliance, data privacy, the compliance piece, I see this as a burden, as another cost. But everything we've talked about from the very beginning here is about attention to data, attention to data, attention to data. And I love what you guys are talking about, not only how you store it, how you utilize it, but also just, how does it fit into everything? And I wrote down a couple of things here that don't you think you have to look at this and how you treat the customer in this, with these privacy concerns, as it's, customers are like your family, right? You want them to make them feel comfortable, right? So it's part of your culture. So your culture is that, we're going to protect hey, I'm going to use this information for this purpose. And when you show the customer you're using it just for that purpose, that's respect. I just feel like there's something in there. And Eric, I don't know, did I explain that well? Do you see where I'm kind of going with this?
Yeah, no, I mean, I think, look, data, data is worth a lot of money. That's the reason why there's laws around it, right? So most retailers don't realize the value of the data that they're sitting on. They don't utilize it enough. But they need to just, treat data like how you would treat your own stuff. Like, you know what I mean? So if you wouldn't, leave it on a computer sitting out in the lobby of your store open for anybody to get access to, with your own information. Why would you do it with your customers' information, right? But you can utilize this data to drive so much in sales. It's so much easier to bring someone back to your store to rebuy from you than it is to acquire a brand new customer. It's always going to be 10 times easier. So if you're not utilizing the data for that purpose, then you're obviously missing out. If these law changes and even this webinar, makes you think of a few things. One should be understand your data better, so that way you can do more, and how to utilize it, how to protect it. Just don't sell your customers' data. That's the big one. Don't ever sell your customers' data. If you sell your customers' data, you're going to be in big trouble.
Let me ask the three of you this. I'll throw this out as kind of a toss up here. Do we feel like there is going to be a national act involved in this? I know there's been some committee work and things of that sort. Do we feel like that's coming? Because if I'm not mistaken, I think that the efforts nationally are actually, surprisingly, in our time and space right now, actually somewhat bipartisan. So do we feel like there's going to be something like that coming down the pike before we see more states jump on? Or what's your gut here, so we can give the viewers an idea about where we're going?
I don't think it'll ever pass. I don't think you'll ever get a federal one, at least not in the next couple of years, probably. I think we'll just end up getting more states that sign on. There's too much money involved and too much lobbying that goes on, that it's going to be really, really difficult for them to get something passed, I think.
Okay.
Yeah.
Because
I agree.
the most recent bill, that one was a very well written, bipartisan support, like it was reasonable. And the fact that one got sent to committee so quick and basically just died and has no Senate support. If that bill can't get Senate support, I don't think you're going to find another one that will.
Laura?
I think the same. I think states will, continue to follow. I think there'll be states that fall on one, extreme end of the spectrum, and states that fall on the others, and then a few in the middle. But I agree. I think there's too much money in lobbying for it to go a different way.
Okay.
Even if you look at the Virginia one, compare that side by side with California, and there's like a handful of differences, right?
Yeah.
Like literally just like just a few. But here we are, there's two different laws that people have to follow,
And that was a question that did come in earlier. Richard, what are the key differences between that California law and Utah, Colorado, Connecticut, and who am I missing?
So the big one for me, at least, is in Virginia, you can opt out of being in data targeted advertising, which is not part of the California. The California is personal information to third parties and such, but doesn't talk about targeted advertising per se. That is actually in the Virginia one, which opens up a whole new fun place for us, because we got to now deal with, if somebody doesn't want to be advertised to, that can be put in there, and that's kind of a funky place in there. The exclusion there of whether it identifies them as a Virginia resident or not is kind of another funky one, because now you could take the factor of them having a 757 or an 804 or a 703 area code, or I think it's 504 is the other one out there, in those phone number sides, and all of those could possibly say they're Virginia. I have a 757, I live in Florida. It doesn't mean that it is, but it could mean. So now I have to exclude these people because that's a risk factor. So there's some other, just kind of those fun little nugget type pieces in there that are different. But as we kind of mentioned, the bigger one there is no consumer can take action on you in Virginia where they can in California. It has to go to the Attorney General in Virginia. So it has to look like you, basically, I don't want to call it egregious, but it has to look like you just completely didn't try. Yeah. And if you're not trying, then you're opening yourself up where, California, there's that open where consumers could take that action.
And also, I think the other big difference is just like who must comply with it, I believe.
Yeah.
So I guess it's just, so this is not just a blanket to say, just follow the California law if you want to just sort of be completely, compliant with whatever the most, stringent law is here in the US. That's a big nuance in Virginia. That's a huge difference that can add a lot of complexity. So what is the suggestion, just still to kind of take an overall stance? How do you, I guess, how do you, so since it's not like, do you don't think it's going to be a national law? We've got state to state stuff. We're not really sure. So what's what is the path that a retailer should take regardless of where they are at this point? Let's make that a takeaway that we give them toward the end of our discussion today. What do you guys think?
I mean, I think from an advertising standpoint, you work with good partners. If you're doing the advertising yourself, obviously you're going to have a harder time because you need to understand, how all these rules work. Companies like ours, we spend great amount of time learning the nuances of all these different things so we can remain compliant all the time. And so, for a retailer, for them to understand or go through and do a privacy analysis with an attorney of all, 50 states and figuring out what their individual liability for marketing in each one of those states, it's a big undertaking. I don't think many are going to do that. So in that regard, it's like, find a good partner and make sure that they're doing right and let them guide you through it. I wouldn't navigate this on your own, but if you are going to navigate it on your own, then you better understand what the rules are and where you are, and have a written privacy policy, disclose to your customers what you're doing, how you're doing it, have a way for them to opt out, and make sure that you can communicate those things both back and forth with the consumer and with all of your partners. It is an undertaking, but it is possible to do.
And I say the word I hate because it gets overused, but it's transparency. The more of that transparency of how you handle somebody's data and what you do on, you define it on your site, you define it in your policy side, you tell them how they can get their information out. Those transparency things go a long way, and they also do a lot to help on the reputation side of it. So if something does happen, here's all the things we do to protect that. And you know what? I can't stop the hacker from, whatever country that came in. I mean, even Google got hacked this Monday from 6 to 9. Everybody's services, Gmails didn't work, everything else, but you didn't see it on the news, you didn't hear anything because they have their best lobbies to stop that. But they were like all kinds of crazy for 3 hours. So, I mean, it's things that happen a lot of times that if everybody's doing the right things, nobody's going to be yelling at Google because they know they're trying their best to do it. You can't stop every action. It's just, making sure that you show that you are making those attempts, you're doing everything you possibly can do to be good to your consumer and good to your customer.
Yeah, I think just to sum it up really like easily, I think that you 4 questions, right? What do we have? What are we doing with it? How are we protecting it? And if somebody asks to get rid of their information, can I get rid of it? And how? Like knowing that you can answer yes. I think that's the biggest takeaway. And if everybody is on the same page in your company, everybody who needs to be from InfoSec and legal that knows the answers to those questions, then everything kind of falls out of there. And
then whole data cleanup and data process is huge, because you just said the last thing there was, can I get rid of it? If it's housed on 3 different systems, you're not sure that they're even talking about it, or you don't know that it's on one and it's on others. I mean, wow, that last one really tells me that as a business owner, I need to make sure that I've got my ducks in a row when it comes to my data my data capture and storage. So one thing I wanted just to ask here toward the end of this whole thing too is that does AI impact any and all of this? I mean, I'm assuming it does. We're just embracing that technology like crazy. We're talking about it almost on a daily basis. So anybody want to discuss concerns there or anybody's reliance on AI?
I think the AI will end up make it easier for people to find out who are the bad eggs, quite honestly, because there's
how so?
Because you can create in generative AI, I create pieces that search out and provide people without policies and where their sites aren't matching. And this, I mean, we're using it currently to go look for different things that are missing in people's websites and stuff, to go through and find opportunities where we would think of how to make their SEO or their SEM stronger and better based on words and things, but it's going beyond that. Now it's content pieces and things. Well, I could do the same thing and write the script in a way that goes through and says, who doesn't have this in their policy? And then if I'm on that, if it opens itself up at any point in time where it is consumer based, that just screams for a law firm to put that together and go after you. So I think there's going to be places where it's going to be really easy to check people's compliance. And that's that would be my fear factor, because there is a lot of tools out there. And there's a great tool that's been built in California, a guy who does the data side. He's marketing a whole entire company that does nothing but secure data for companies. and he's getting a lot of, street cred for it, which is great. But that didn't exist 3 years ago. There was not a whole entire business model on securing data for what you have as your online type stuff. That just wasn't there. Now it's, it's set up that way. So it's also creating new businesses and all because they have to.
Mark, I would say also one thing about AI that I think retailers need to be careful with, and this goes back to earlier when you were talking about the GDPR stuff and how you have to be narrow with your usage of people's information. I don't think that you could make the argument that by buying furniture and giving them your information for delivery gave that retailer the right to load that consumer's information into any sort of large language model to do any sort of analysis on it. And then you'd have to be really careful because a lot of these AI tools are open source, and you might also be giving up the ownership rights to that data. So therefore, now you've really sort of given away customer data without the intention of doing so by participating in and using some of these apps, right? So, so I would just be really careful about putting consumer information into any sort of AI app that's out there right now without really understanding who owns the data. Like, are you giving it, are you contributing to the model? Because if you're contributing to the large language model by giving that data in order to participate in the usage, I think you probably have some pretty big issues. Yeah,
I agree with what Eric said.
Wow, that's a cautionary tale right there. Appreciate that. Last question for us today. Is this something, and this I think is a good question that came down the pike here. Is this something that you should also have in some ways memorialized in your store? I mean, a lot of what we talked about here is, is that this opt-in, if you're going to text somebody, it's all in the digital channel that we're talking about and where that data is being protected. Is this something, should there be anything that these folks have in store just to make sure that customers know that walking in the door, or is that overkill?
I mean, it can't hurt to at least have like a QR code that they could scan at the register to get a copy of your privacy policy. That couldn't hurt,
Yeah, because I say usually you put it on the website, and depending on how big it is. I mean, if it was a nice simple one pager, yeah, it doesn't hurt. But I agree. I like the idea of the QR code piece, where it's just if you want to read it, if you want to, and also if you want to opt out of my information, here's the way to do it too, and just have it where it's very simple to get to, and you're not making it difficult for the customer to get there.
Great takeaway, Laura. What do you think? Oh, I caught you. Sorry.
Yeah, I don't know. I guess it just really depends on how you as a store interact with your consumers at the end of the day. I mean, as long as your ability to provide them notice and get their consent isn't like some sort of fine print, hard to find,
right?
Then I think you're okay.
Okay, awesome. This has been kind of a whirlwind hour. We've covered a lot, but boy, I'll tell you that. A lot of takeaways. I think there's going to be people that are going to watch this a second time, but I think that the one thing that you all three said at the top that just carried us all the way through is know your data, where you're keeping it, how you're keeping it, simplify that, keep your scope narrow, and by doing that, I love the biggest takeaway. And Eric, you said it first, is that you know your data, then you've got much better chances to really connect with your customers, and that's where you can find growth out of this whole thing. So you're not just throwing money down a hole here of compliance. It's like, no, you got a real opportunity here to really get your house in order. So I want to thank our panel. Eric Grindley joining us. He's CEO and founder of Esquire Advertising. He's in Las Vegas right now. We have a furniture market coming up, so he's dealing with 100 and who knows what. But Eric, we appreciate it. Hey, listen, you just wanted to get inside with air conditioning and cool water, so I understand what you're saying.
Yeah.
No, appreciate you being here. Richard Harris joining us from Orbit Interactive. Richard, we always enjoy having you. And Laura Mahoney, General Counsel for Strong DM Inc. Appreciate all of you. And I always like to end every one of our sessions by saying that to all of you, we wish you not only really good sales, but good health as well. On behalf of all of us here at HFA, I'm Mark Schumacher. We will see you next time. Thanks, y'all.
Thank you.